Excellences, Mesdames et Messieurs.
Your Excellencies, ladies and gentlemen, dear colleagues and dear auditors, dear listeners, those of you following online. According to the Academy's tradition, we tend to start when the bell rings, or maybe 3 minutes later. This time, we've let a little bit more time go by since the bell rang, and I can see that giving you that little bit of extra time has allowed you to take your seats. The room is full. I therefore declare this colloquium open, and I would like to call our first keynote speaker, the President of the Curatorium, Professor Yves Daudet.
Madame la Présidente de la Cour internationale.
Madam President of the International Court of Justice, Your Excellencies, ladies and gentlemen, dear friends, dear alumni. I understand there are some alumni present in the hall today. The last colloquium, organized by the Academy of International Law, was in fact to celebrate a centenary already. We're not specialized in centenaries, but as it happens, the last colloquium was also for a centenary, as it happens. And it was the centenary of the second conference, the second peace conference held here in The Hague, which was entitled Topical Events regarding the events of 1907. It looked at texts that were adopted at the time. At the time, we already had computers, we already had the internet. But to be perfectly honest with you, the audience was not so familiar with the use of these devices, so we organized things a little bit differently. Today, we would no longer do things the way we did back then, it has to be said. And since then, we haven't organized any other colloquia because the Curatorium noticed that in scientific, academic colloquia, which were being organized here and there, first of all, there was quite a plethora of such colloquia, and secondly, it tended to be narrowed down to those who took the floor, those who spoke. It was a very narrow audience, if you like, just between those who were called to speak, to present. There was not much of an audience, so to speak. Now, today, there are many of you present in this hall, and I think that that goes to prove that the Academy remains very attractive, and I can but thank you for your presence, and I can but be happy about that state of affairs. So today, we're celebrating another centenary through this colloquium, and it's not totally unrelated to the one I just mentioned, because the Academy, as we said yesterday, the Academy is part of that momentum, if you like, this movement, end of the 19th century and moving into the beginning of the 20th century, the first few years, shall we say, of the 20th century, part of that movement. And this movement, at the time, was regarded with great enthusiasm, perhaps also some naiveness, by some at least. We looked at it with enthusiasm at the time. Today, we very much set great store by it still, but I think we interpret it slightly differently. We're perhaps more tangible, more efficient, more pragmatic, if you like, in our vision of this movement. And today, what the Academy does, and incidentally, we have a podium here before us, which I think illustrates that point. There are two protectors, if you like, two guarantors, and perhaps I could mention them chronologically. First of all, I would mention the President, and I thank you, by the way, very much indeed for attending this session, the Institute of International Law, the Institut de Droit International. I have to mention you because the IDI was, in fact, the first to have had the idea of an academy. It wasn't necessarily a very well formulated project at the time, but it was an idea, and you were the first to mention this idea of an academy, which then gained some momentum too. It took some time, like any project of that order, it took some time to materialize, but I think in a way it was good for it to mature and to be well thought through. And therefore, if we're celebrating a centenary here, we're also celebrating the input of the Institute of International Law, the IDI. We're celebrating the fact that you gave us this trigger, if you like, to start the process. And it goes to show also that, of course, the IDI has not lost interest in the Academy. Far from it, you continue to support it, for which we thank you very much, Mr. President. And the other pillar, the other protector, is the court, of course. And I would say that the court is not just our neighbour, geographically speaking. The president of the court is present here today. There are several justices, several judges of the court also in the hall today. I said it yesterday, I'll say it again today. For us, it really is very encouraging to see you here. And it is, if you like, a guarantee of this continuity. The court has always unfailingly supported the Academy. That continues. I've said this many a time. I'll say it again. Without the court, without the support of the court, without this attitude, if you like, this availability of the justices, making themselves available to the Academy, available to its alumni, without that, the Academy would be certainly not nothing, but not what it is today. And therefore, these two pillars are of paramount importance. And I would like to take this opportunity to thank both of them most sincerely today. And furthermore, there is a small coincidence of dates. This is a beautiful summer. We're opening this summer. Now, the summer of 1923, the court had already handed down some advisory opinions, for instance, the Wimbledon opinion, and the Academy opened its doors during that very same summer. And it didn't really shut its doors from there on in, except for, of course, the period of occupation, a very sad period of history where materially, physically, it was not possible for the Academy to continue with its activities. However, it closed only temporarily. It opened its doors as soon as the war was over. And again, the doors were not closed again. I mean, there was a very recent period, you'll remember, namely the COVID pandemic, and a lot of institutions during the COVID pandemic found it very difficult to operate, did tend to shut down. But the Academy, and I think we can hold our head up high for this, and I would like to pay tribute to the Secretary-General, to the team of the Secretary-General, the Academy did not cease to operate. It worked differently. We couldn't meet physically. That was not possible because of restrictions, but we continued with our work. It was mentioned yesterday, thanks to the technical possibilities afforded by remote learning. So we were able to continue. We couldn't meet here in The Hague. That's what we were missing, if you like, this in-person meeting with the court, with the justices, and indeed with other speakers who, of course, come here before us and speak to our audiences, many diplomats, many politicians, and so on and so forth. That whole environment that's so precious. And, of course, the social side of things, the wonderful contact that alumni can actually establish with people from other countries, other horizons. It's one of the great assets. I've often said this, the auditorium of the Academy, when it's full, to the rafters, it's a bit like the UN General Assembly. There's so much diversity, such contact. So for all of these young people, it is quite an experience. And for some of them, of course, it will be an experience they'll want to live again. It will be part of their profession going forward, their career. Not necessarily for everyone, though. Anyway, the colloquium takes part with that as a backdrop, with that as a context. And we are here, of course, to celebrate the 100th anniversary of this Academy. The colloquium was made possible thanks to the cumulated effort of Judge Tomke, first of all, his great ideas. He led, of course, the committee that prepared this centenary celebration. So thank you to Mr. Tomke, and thank you also to Professor Thouvenin, our Secretary-General here at the Academy, who has worked tirelessly. And he is such a talented legal expert, of course, as well. And in a few moments, I will have the great pleasure of handing over the floor to him so that he can make some comments regarding the different topics that have been placed on our agenda for this colloquium. Thank you for your kind attention.
Excellences,
Your Excellencies, Madam President of the International Court of Justice, Mr. President of the Curatorium, Mr. Secretary-General, ladies and gentlemen, dear colleagues, dear friends. How very nice, how very kind of this young 100-year-old Academy of International Law to have invited the president of an even more venerable institution, namely the IDI, the Institute of International Law. Thank you for giving us the opportunity to say a few words by way of an opening during this opening session of the colloquium. We are celebrating the centenary of our little sister, so to speak. It's very moving. I'm much touched. Professor Daudet just said this, and we've said it previously. In a way, the Institute did actually very much contribute to the creation of the Academy. In fact, in the book that celebrates the 150th anniversary of our institute, this particular moment in history is recalled. It's mentioned at quite some length, in fact. There are a number of articles that refer back to this relationship between the Academy on the one hand and the Institute on the other. The Institute was born in Ghent, 8th of September 1873, which means that this year, between the 27th of August and the 2nd of September, we'll be celebrating not our centenary, but our 150 years of existence. And it will be happening in Angers, the beautiful, beautiful city of Angers. There have been surveys carried out, and according to these surveys, Angers is the city in France where it's actually the most agreeable to live and to pass time. The Institute was founded by 10 very famous international law experts. I would mention Calvo, Blunchley, and of course Tobias Asser. Tobias Asser, whom we spoke about quite a few times yesterday, who gave his name to a different institute and a different academy. But all of them very much devoted to applied research, to critical thinking, to some serious thinking about the development of international law and to the teaching thereof. Furthermore, of course, this happened in the beautiful city of The Hague, which calls itself the capital of international law, quite rightly so. We did actually talk about it as a mecca of international law yesterday, you'll remember. So, the Institute was very much there right from the beginning, and we're here for this colloquy too. And I think that it goes to show that there is great complementarity between our two institutions. I mean, the Institute, my institute, is more focused on applied research, and what I mean by that is that its work leads to the crafting of resolutions that are supposed to steer the international activities of states. The Academy, for its part, is more focused on teaching. However, since 1957, it's also, of course, been responsible for running a research centre on international law and international relations, and that gives young researchers, young academics, the opportunity to undertake research jointly and even possibly to publish on topics which I actually think are very, very promising and very interesting. Another commonality between our two institutions, I would say that we both have this pluridisciplinarity or interdisciplinarity. I mean, interdisciplinarity from the legal point of view, and in fact very often purely from an international law point of view. I would even call it bidisciplinarity, personally. I would say that both institutions are open to public international law and also to private international law, so bidisciplinary in that sense. Incidentally, the 10 founders of the Institute generally tended to have skills in areas that we nowadays tend to think of as separate, discrete disciplines, which I think is actually an erroneous perception. I mean, this separation is particularly clear if you look at the way in which the summer courses of the Academy have been organised traditionally. But in a way, this differentiation was mitigated, I would say, through the creation in 2019 of the winter courses, because in the winter courses you just have one session, and one session that covers both public international law and private international law. And I think there's a lot of very interesting cross-fertilization between the two. Similarly, the discussions that we have in our institute to look at draft resolutions concerning private international law, these discussions are very, very enlightening, even for those of us who might come from a more public international law background. And it goes to show that international law experts can only really cover these subjects satisfactorily if they take into account both planks, if you like, of international law. And also, of course, languages. In the same spirit. Like the Institute, the Academy too started off by being exclusively French-speaking. In fact, it started off purely French-speaking, but one and the other progressively they took on board English as well and started using English, but without forgetting the language of Montesquieu. Very important. So bilingualism is also something that brings us together, French and English. However, that to me is not the most important. I mean, linguistic issues or language issues are relevant because to a very great extent it means that we have interactions between civil law approaches and common law approaches. And I think that that cross-fertilization is also a great asset for our respective institutions. Another point, another commonality between our two institutions, the efforts, which I think are actually quite successful. I understand there's a lot still that needs to be done, but I think both are trying very hard to become more diverse in terms of gender, for instance, in terms of geographical backgrounds, in terms of nationalities, in terms of also legal schools. We're trying to be ever more diverse. I sometimes wonder, actually, is there such an enormous difference between, the approaches that we have in different countries, bearing in mind that most of us tend to attend the same universities at the end of the day. Now, before saying a few words about the topics of the colloquium that brings us together, before moving on to that, let me just take a little trip down memory lane and speak about my nice memories of the Academy. I actually go back quite far. I 3 times was a student here in the Public International Law course. First time was in 1967. In 1967, I had the honour of attending the general course dispensed by Mr. Jennings. I think I was perhaps a little bit too wet behind the ears in terms of international law at the time, so I maybe didn't gain as much from it as I should have, but it was very enlightening nevertheless. 1968, I was busy on the barricades with the revolution, but I came back to The Hague in 1969 with 2 immense courses. First of all, the general course dispensed by Wolfgang Friedman, and then also the course dispensed by Prosper Weil. Absolutely wonderful, subject to so many discussions. He talked about the contract between the state and the individual. And third time round, I came back in 1971. I hardly dare mention this particular visit because I was actually like a free auditor. I was a clandestine, if you like. I was in the hall. I wasn't properly registered, but I just came to listen and to follow. Anyway, I remember at the time, you could come into the Palais without these quite harsh, I would say even excessive controls and checks that we have nowadays. Anyway, at the time, 1971, I already met Roberto Ago, and I was absolutely amazed by this encounter. And during the course of the 3 sessions, I founded some friendships with other people who were just as obsessed with international law as myself. I'm thinking here of Raymond Rangeva, who's been a friend of mine since the session we attended in 1969. And I think that the fact that we can have these exchanges, these contacts, I think that's one of the greatest achievements, one of the greatest achievements of this Hague Academy. Because obviously I remember my time here when I was an alumni, not the same as this beautiful room that we are meeting in today, but despite the fact that time has gone by, despite the fact that there's been a generational turnover, if you like, nevertheless, yesterday I found myself thinking back to the past, listening to, for instance, Mrs. Zhu and others who spoke yesterday afternoon. I felt this spirit, I felt this experience of the Academy, and I know that their experience, the spirit that they shared with us, was very much also my recollection of my trajectory here with the Academy. Second episode, this time I was actually in charge in 1985 of the French language seminars, and I managed to establish a very firm friendship with Manfred Lux, Roberto Algo once again, and I met with many brilliant students, some of whom have actually stayed my friends. It's only in 2007 then that I came back to the Academy. Relations started up again, and that was thanks to the proposals by the Curatorium and Yves Daudet, who was Secretary General at the time. He asked me very kindly to give an inaugural lecture. And then 2018, I was able to dispense the general course. It was a very fruitful experience. It was hard as well, and I have to confess that through because of my own fault, I wasn't able to address it in the best possible circumstances, but still quite an experience. So, ladies and gentlemen, what I'm telling you here is a long, long, long relationship, like a roller coaster, and lots of friendships with this Academy that hosts us today. And I'm very grateful for that. I'm also grateful for, of course, the building next door, the very important building next door. It's thanks to you that I have learnt so much as well during the course of my career. And I'm so full of admiration for these justices, these judges, who for some 40 years now have been so stoical, listening to pleadings, for instance, which are very long. Thank you for your forbearance and your patience. So without any doubt, the Academy, like the Institute, is in the vanguard, in the front line when it comes to defending and promoting international law, both public and private. And we know that that international law needs this support, very much so, particularly public international law. I mean, I say that to the extent that a distinction between public and private is actually relevant, but they certainly need it. Now, the circumstances that we meet in today. I understand that, of course, we should be in a spirit of consensus. We should welcome the progress made by international law. I understand that's the expectation. One should be polite. One should follow the protocol. But actually, I have to confess that to me seems rather difficult. It's difficult because there's a war being waged some 2,000 kilometers away from here. And it's not so much because it's close to us geographically that it's problematic, this war. It's because any kind of war of aggression is a violation of the law, and it imposes untold suffering on humankind as a whole. I also think it would be rather difficult to remain polite and diplomatic, bearing in mind that there are inequalities between peoples, between human beings, and these inequalities are growing. They're certainly not going away, not being removed. It also seems difficult to me because of human rights, whether you're talking about civil and political rights, economic, social, cultural rights. All of them are being questioned. They're being questioned because of individualism or particularism, which flies in the face of universalism. And also, I would say, it is difficult because life on Earth, our common home as humanity, life on Earth is being threatened. There's an overexploitation of our resources by a greedy minority. So, to be perfectly frank with you, ladies and gentlemen, to remain polite, to keep silence in the light of all of that, to me seems not only difficult, I think keeping silence would be absolutely unconscionable. You cannot remain silent. You have to face the challenges. You have to worry about what's gone off the rails. You have to flag it. You have to speak out. And you have to be blunt. Speak truth to power. Time is not for excuses or academic politeness or polite conversation. No, I think more than ever before, legal experts and their institutions should not be politically neutral, and we should not lack bravery. I very much hope that this beautiful colloquium, to which we've been invited, which has a programme, by the way, which I think very much encapsulates the different aspects and challenges that international law is facing right now, I really hope that it will be a forum within which we can have frank discussions, not the usual hushed tones, and Jean-Marc Thouvenin talked about a critical spirit yesterday. I entirely agree. I think that the colloquium will be all the more interesting if we do apply a critical spirit. Thank you very much. I end in English since the Academy is a bilingual institution. Thank you.
Bonjour à tous. Conformément à la tradition bilingue, ici à l'Académie et aussi à la Cour, j'ai pensé commencer mes remarques en français, mais en tant qu'unique anglophone ici, sur ce podium, et comme Peter Truboff l'a dit hier, pour protéger la langue française, je vais continuer en anglais. And with that, I thank you, Mr. President, Mr. Secretary General. I thank Professor Pellet as well for his remarks. And Excellencies, dear colleagues and friends, ladies and gentlemen, it's truly an honor for me to participate in this colloquium today celebrating the centenary of the Hague Academy of International Law. So as we gather to celebrate that 100th birthday, I'd like to recall that the judicial institutions that are known collectively as the World Court can also be seen to observe a centenary of sorts this year, because just a few weeks before the inauguration of the Hague Academy in 1923, the Permanent Court delivered its first judgment on the merits in the case concerning the SS Wimbledon. Well, given the similarity of these two origin events, we might think of the Academy and the Court as twins. And like human twins, the two institutions do share a common heritage. Both are born out of a commitment of international law, and both adhere to a tradition that we call bilingualism, but like Professor Pellet, I have to say that it's a tradition that has a deeper significance because it aligns with what we need to appreciate fully both the common law and the civil law traditions. Well, as related as these two institutions might be, we have to regard them not as identical twins, but rather as fraternal twins who differ in a number of respects. And it's precisely because of those differences that the two institutions are able to complement each other in confronting the challenges that we face in international law today. A fundamental difference lies in the degree of freedom within which each institution addresses questions of international law. A court, including the ICJ, operates within what my late friend David Caron called a bounded strategic space. The scope of our work is defined and limited by the statute of the court and its rules. By contrast, the Academy's traditions and working methods herald and promote academic freedom, which the Academy can enjoy to the fullest, located as it is in a host state that values open and robust exchanges of differing points of view. So I'll offer a few examples of the implications of these differences. First, the court is not free to choose the topics on which it will focus. Its decisions respond to specific issues presented to it by states or United Nations organs or agencies. For example, I'm often asked about the court's contribution to space law, or more recently, about our jurisprudence on cybersecurity. And I see disappointment on the face of the questioner when I respond that these issues have never been placed before the court. So I explain that we are ready to consider any question of international law, but that we don't set our own agenda. The curatorium is in an entirely different situation. As noted by the former Secretary General Dupuy on the occasion of its 50th anniversary, the Academy performs a dual role of revelation by taking stock of and rationalizing developments in international law, and anticipation by exploring forward-looking topics. And the course that was delivered by Judge Manfred Laux in 1964 on the international law of outer space fell, no doubt, into this latter category. 60 years on, that course remains relevant to scholars and practitioners, even if the subject has not yet found its way onto the court's docket. Secondly, when parties to a case present two opposing views to the court on a question of law, the court is expected to answer the question. And no one in this room will be surprised to hear that when 15 or 17 seasoned international jurists get together in a room, we don't always find it easy to agree on a point of law. Those challenges of reaching broad agreement on the operative paragraph of a judgment or on supporting reasoning can at times lead a multi-member court to adopt a degree of opacity in its reasoning, resorting to techniques like the so-called least common denominator drafting. Moreover, sometimes it's not necessary for a court to answer every question of law on which the parties disagree in order to reach its decision in a case. So when the ICJ arrives at a decision without answering all questions of law presented in a case, at times we hear disappointment from commentators, especially those in academia. However, when the court is deciding the merits of the case, it must accord priority to its primary task, which is to deliver a judgment that settles the dispute before it, even if the judgment leaves open certain matters raised by the parties or fails to shed light on areas of international law that might benefit from clarification. Over my own career, I've noticed that discussions about contested legal issues lose some of their richness when the objective is to agree on a particular text, whether that's a judicial decision or a treaty provision. The participants gravitate towards various forms of so-called constructive ambiguity and thereby fail to confront and disentangle the knottiest legal questions. By contrast, when a question of international law is addressed at the Academy, this institution is not bound by the intellectual straitjacket that comes with the need to produce a binding text on a specific case. Rather than striving for an Academy position on a given legal issue, the curatorium makes a deliberate effort to select topics and lectures reflecting what Professor Daudet has called in his writings the widest variety of viewpoints and ideas. A third and final difference between the two institutions is a consequence of the fact that the ICJ is both a court of last instance and a court of first instance. It must not only pronounce on the law, but must also settle disagreements over facts. The faculty and students at the Academy, by contrast, are free to consider questions of international law in general terms without having to apply the law to particular factual circumstances. After years of sifting through evidence on topics like the amount of silt in a river, the use of lethal methods in whaling, and the quantification of damage caused in a large-scale armed conflict, I have at times envied those in the Academy building here who have the luxury of discussing abstract questions of law. However, this envy on my part is tempered by my conviction that the application of law to facts helps to shine a light on nuances and complexities that may be obfuscated by the pronouncements of a rule in the abstract. In making this observation, I acknowledge my own training in the common law, in which the law is both developed and evaluated through testing various legal propositions against actual or hypothetical factual situations. Because the legal conclusions expressed in the court's judgment emerged from a process of considering the law and the facts, we have both the challenge and the opportunity of arriving at formulations of the law that avoid overly broad or overly narrow legal propositions. As I've suggested, the different mandates, histories, and approaches of the court and the academy give these two twin institutions distinct yet complementary roles in tackling the current challenges faced by international law, a topic that was wisely selected by the organizers as the central theme of this colloquium. In recent years, states and organizations trying to pursue important objectives within the United Nations framework have increasingly expressed frustration at roadblocks arising within certain organs of the United Nations, for example. And as we all know, a number of issues on which limited headway can be made in New York have been placed before the court. Looking ahead, the court can be expected to do its part while remaining in the bounded space available under its statute. And in parallel, we can be confident that the Academy will build on its 100-year tradition of promoting the pluralism of ideas, of synthesizing the law, of anticipating emerging questions, and importantly, of training successive generations of international lawyers on whose shoulders will rest the burdens of overcoming the challenges that are so evident today. I thank you for your kind attention.
Madam President, Excellencies, dear colleagues, it's very complicated to take the floor after such authorities. I'm going to be very simple, and I would like to explain the concept of the next couple of days. The title of the colloquy is Challenges of International Law at the Time of the Centenary of the Hague Academy of International Law. We have a fine program. It's well prepared, part of which is in English, the other in French. And this is a theme which we chose as it focuses on the key issues of our contemporary world, of the present day, and maybe as well of the future, and which seem the most relevant. A lot of work, in fact, tends to focus on the past, which we revisit. And in fact, we have decided to give thought to the present time and what is in store for us and maybe what needs to be done. So we have tried to highlight these trends, the strong trends in international law, irrepressible trends possibly in international law. I believe that they are irrepressible. Sometimes certain can express certain doubts and, in fact, be angry about what is happening today. Part of the world is under the shadow of imperial madness. But these days passed, and the challenges we're going to be discussing today are irrepressible. But maybe discussions will, in fact, contradict that today. We're going to focus on the fine notion of public interest in view of international law. Does it have a meaning in international law? How is it relevant for international law scholars? We're going to hold 3 roundtables: public interest and international law, followed by public interest and litigation, public interest and the interpretation of treaties. These are workshops which, in fact, will receive the main scholars of international law. In fact, you will only hear these well-known scholars' voices we have already heard in this auditorium or next door in a former previous building which was demolished, but in fact I welcome the fact that this building was replaced by this one. So Public interest in international law. We're going to have those 3 workshops moderated by well-known figures, chosen, in fact, for their discipline, their ability to ensure the proper schedule, and they will, in fact, lay down the law, so to speak, to ensure that all of you here will also be able to take the floor and maybe put questions to the speakers and say what you have thought of their work. We've published this online. What I have called, in fact, the preparatory work. We're not going to be adopting any resolutions at the end of this colloquium, but I hope that we will be able to draw some conclusions thanks to our discussions and the preparatory work. And this afternoon, following a light lunch, which you will receive in the foyer. I don't know whether there's a real translation for light lunch in French. Maybe déjeuner sur le pouce. And we will therefore be able to come back to the auditorium quite quickly, already at 2 p.m. Well, we'll see. It remains to be seen whether we stick to the schedule. And we will then address the issue of the humanization of public international law, in fact, international law. And indeed, I want to draw your attention to the fact that there are themes addressing both public and private international law in this program. So you have no doubt understood that this program was conceived by Judge Tomka and by myself, partially, and on the second day there's a session which is entitled The Law Applicable to International Arbitration, but without any question marks, whereas all the other topics today, in fact, end with a question mark. And in fact, I didn't want to design this roundtable by expressing it as a question. So that afternoon we will be, humanization of public international law through its rules, humanization of public international law in practice, and humanization of private international law. So well-known scholars, and again, they will have to stick to the rules and stick to the schedule. So tomorrow, of course, we shall continue and address a concept which is slightly different, where in fact we shall revert to some key issues which have been addressed by the Academy in its center of its research and study center, which is a body, a tool which is absolutely crucial in the Academy, and experts and professors guide young scholars, young legal experts to give thought to current issues. And then in books which I believe become crucial, they express their thoughts about current issues under international law. And you will no doubt have noticed that these are the questions which we find challenging, which Alain Pellet has said, the ones that need to be addressed henceforth. Global finance. Can global finance be subject to international law applicable to arbitration? And again, we shall see how the professors will deal with that. They are, in fact, expressing this very precisely. What can be expected from international law? How can we improve the effectiveness of international law? Should and can extraterritoriality be contained? Can outer space be res communis? Can international law help facing epidemics? Can it text help us to deal with epidemics? And finally, acclimating international law with climate change towards a global reset. And we shall conclude with a question about a new momentum in international law. In fact, a while ago, the Collège of France under Professor Laurence de Choiseul organized brilliant colloquium concerning the challenge of climate change. And listening to the speakers, we realize that, in fact, today we're witnessing a trend of the environmentalization of international law over and beyond humanization. And maybe the last roundtable will shed some light on that current momentum or trend. So I thank all these fine scholars who have kindly accepted to speak at this colloquium. The Academy is an exceptional institution, and in fact, when the Secretary receives emails, I would just like to say that I shall be there. I would like to thank each and every one of you. I shall now in turn become a student, just like the attendees during the summer courses, and I call to the podium with no further ado to attend the first roundtable, moderated by Professor Yves Daudet. I call on Professors Rüdiger Wolfram, Professor Bingbing Ya, and Professor Yuko Nishitani. And I would like to thank President Donoghue and Professor Pellet for their brilliant presentations. Thank you very much.